In the Ajay case, I took the opportunity to reflect on that weakness that I noticed. And are these, and these are not so to me, they lack the gravity. They lack the gravity that would lead to a grave outcome, such as the removal of the head of an institution of justice. I've deliberately phrased myself that way. It trivializes the position, and I wonder what this is going to lead to further on along the line, because every judge is fair game and every chief justice is also fair game.
I mean, is that to suggest that you suspect there could be a ripple effect in that?
Oh, definitely.
Any matter?
It's not suspect. I foresee, not tomorrow, maybe not next year, maybe not in 5 years' time, but along the line, yes, unless those provisions are dealt with effectively in a revised constitution.
Maybe a more direct question. I have seen the letter that was written by the Secretary to the President to the former Chief Justice.
And that's the other thing. A warrant, a person holding a presidential warrant, that's what the position is. You become Chief Justice because you have received a presidential warrant. You can receive all kinds of letters that you are hereby appointed, but if you don't have that warrant, does that make you Chief Justice? Yeah, okay. So if you're removing the person from the position, is it a subordinate who signs the letter? Is that the way it's supposed to be done? That's just by the way, food for thought.
Yeah, but I've seen a warrant as well signed by His Excellency the President. So
why are they showing us that one? I've been receiving all kinds of messages, and every one of them is only bringing out that letter. And in any case, is it polite? Is it proper that it should be a subordinate who writes a letter of removal to a Chief Justice? Really?
And so that's the voice of Madam Sophia Akuffo, who herself is a former Chief Justice. And she was having that interview with my colleague Joseph Akpaloo. The full interview is on our YouTube channel, so you can log on and then also get a better and further understanding of how the conversation went. But clearly, she disagrees with the entirety of the process that led to the removal of Madam Gertude Torkonoo, who until recently was Ghana's Chief Justice. So varied reactions have been coming in regarding this removal. One of them is coming from the Office of the Attorney General. Deputy Attorney General Justice Fremsai has been responding to the comments of Madam Sophia Akuffo. Let's listen to him.
As you know, have been, if you're able to demonstrate that the person in office has been incompetent, if you're able to prove that the person has misconducted him or herself, or that the person is infirmity of mind and body, that is the principle in the Constitution. 3 grounds. If you're able to satisfy any of the grounds, the person goes. And I wouldn't be looking at the fact that the person is coming with the president and is going with the president. And would you want a Chief Justice who has misconducted him or herself, or who is incompetent, to remain in office across presidents, or you want Chief Justices to be effective in their offices across presidents? I think that is where the question is. Do we want a certain standard to be kept, or we want just the person to be in the office for as long as we want? Don't you think that there's another side of this which would keep the occupants of the office on their toes? Because, for example, when I listen to the former Chief Justice, I get the impression that she herself probably had been doing some of these things when she was, or did some of these things when she was in the office, because clearly she didn't think it was a big deal, right? Let me ask you, is it a big deal to you? No, I want you to, is it a big deal to you? This, the allegation we've heard, which is not being denied by saying that it is just something small. Is it a big deal to you? If it is it? I want to know first.
To the extent that a committee has looked into it, I think what we have as a fact-finding matter is what a committee has put out there. But I'm asking you, in your assessment, a direct question, which I asked.
Let's summon this first. No, let's summon this first.
Yeah.
You see, the former Chief Justice is not saying that the allegation is false. Her position is that it
doesn't meet the standards.
It is normal. Let's let it go. Let it slide. Which gives me the impression that perhaps even when she was in office, probably she was doing the same thing. And I'm asking you.
That would just be an assumption that you.
That is clearly an assumption. That's why I said it's an impression.
Do you think the former Chief Justice got a fair trial, if I'm to put it that way?
It is fair, because personally I was involved in. I conducted all the cases in defense of the Attorney General, in defense of the committee. I was the one in court, and my argument has been one that is fair. It is legal. It is fair. It is reasonable. It meets all the constitutional standards for administrative inquiry.
And you heard the words of Justice Sremsai, Ghana's Deputy Attorney General, who has been responding to Madam Sophia Akufo, former Chief Justice, on the processes that led to the removal or dismissal of Chief Justice Gertude Torkonoo. So many reactions have been coming in, like we indicated. Well, the latest regarding reactions as to whether or not the Chief Justice had erred in any of her dealings when she was active Chief Justice is that she went to the ECOWAS court. She escalated the issue to the ECOWAS court, and following the letter that was released on Monday about her eventual dismissal, she has activated the protocols of the ECOWAS court, asking them to expedite their decision in how they intend to deal with Ghana. So Christabel is with us and would walk us through the specifics of what the Chief Justice is seeking from the ECOWAS court.
So this is what the former CJ is seeking from the courts in this fresh move. One, an order that the plaintiff or applicant, which is a former CJ, has made out a case entitling her to the reliefs sought in the originating application. She's also seeking that an order entering a default judgment in favor of the plaintiff or applicant, which is a former CJ, due to failure of the defendant or respondent, which is the Republic of Ghana, to file a defense, and for such order or any orders as this court may deem fit. Now, somebody might be asking, what are her main concerns? Now, one, court rules require responses to case to be filed within 30 days. Also, the Republic of Ghana has failed, neglected to file a defense within the timeline given. This means the Republic of Ghana has abandoned the right to file a defense. Martin, the Deputy Attorney General, Dr. Justice Sremsai, has been explaining why Ghana is yet to file a response to the case filed by the former Chief Justice at the ECOWAS court.
Our preliminary thought is that if we are objecting to the jurisdiction of the court, and the court has taken argument and has adjourned to give a ruling one way or the other, we do not exactly think that we have to file on the substantive issue, because the question before the court is whether the court has jurisdiction. The court has to clear that aspect first, and when it says that it has jurisdiction to assume, then they will order us to file our defense. And indeed, if the court was interested in getting the court could have ordered that we should file our defense together with our preliminary objection, because we were heard. It's not as if we argued that matter in court, in the ECOWAS court, and we were heard. And the court in adjourning didn't give any further direction. They told us that they are rising, and then they have adjourned the case, indefinitely. And when they come back, they will give us further directions. So we were waiting for the court to give us further direction, only to be served with a notice for default of defense. So that is where we are at the moment.
So what are the next steps? You'll be applying for that to be thrown out as well?
Yeah, we would have to file to oppose the application for default judgment because, like I've explained, the court did not order us to file our defenses.
You're a legal scholar yourself. I mean, the outcomes of that court decision, we know how our jurisprudence operates. Does not, even if we sign treaties, it do not automatically become law here. I mean, the outcome of the decision, whatever decision will come from the court eventually, how do you see it playing out here in Ghana?
Yeah, so currently, because the ECOWAS court has not been incorporated into our legal system, the decisions of the courts are sent in to us here in the Attorney General's Department, and it's an executive. Within the framework of government, we have the executive, the legislature, and the judiciary. The fundamental principle is that in dualist countries like Ghana, the courts do not see international agreement unless they have been, ratified by Parliament into domestic law. Then the courts can see it. So the Supreme Court, technically speaking, cannot see whatever, or is unable. All the courts in Ghana are, let me put it literally, they are unable to see what is happening in ECOWAS because we have not domesticated the ECOWAS. However, governments can decide, that is, when I say government, I mean the executive. When it is served on us, the government of Ghana as the executive may decide what to do with the decision. And that is not to say that I have predicted what government of Ghana would do. Government of Ghana would decide whether to grant the award, or, if the court grant the award, whether to pay or not to pay. Whichever way, the ECOWAS courts can hold the government of Ghana to not comply with the decision because we have signed an agreement. So at the international level, the ECOWAS court is also not aware of the divisions we have in Ghana's executive, legislature, judiciary. They are aware of government, Ghana as a country. So if they give a decision in that court, as far as they are concerned, the decision must be implemented. If we do not implement it, it could be enforced at the ECOWAS court, but the court of Ghana are not aware of these things. I'm saying it in a very vivid form. They are not aware, or they don't have what it takes to see what's happening in ECOWAS because Parliament has not yet opened their eyes to what's happening in ECOWAS. So it's a dualist situation. We have domestic law, we have international law. A lot can happen there without coming into domestic law.
A more direct, simple question for an ordinary man. In the event the court, one of the preliminary measures she was asking for was that she should be reinstated when the suspension was enforced. If the court says she should be reinstated, what will happen?
We'll cross the bridge when we get there.
And so that is Justice Stremsai, Dr. Justice Stremsai, Ghana's Deputy Attorney General, responding to questions from Joseph Akpaloo, my colleague here. Let's go to the phone lines now. We've been joined by the former director of Ghana School of Law, Mr. Kweku Ansah-Asare. Mr. Ansah-Asare, good evening and thank you for joining us on 3FM.
Good evening, my brother. Thanks for having me on show.
Right. There are a number of things to unpack here, but let's start from the former Chief Justice Sophia Akufo's thoughts that she shared on the process that the government undertook that led to the removal or dismissal of Chief Justice Gertude Torkonoo. She believes that the entire process was flawed or shouldn't have happened in the first place. You agree with her or have a different opinion?
Well, I have a different opinion. As I said this morning, I don't want to comment on the substance of the argument. My comment is therefore limited to the issue as to what she did, was appropriate or inappropriate. As a member of the Council of State, she has subscribed to two oaths, the oath of member of Council of State and the oath of secrecy. And both oaths are binding on her. And the effect of the subscription is that she's going to abide or observe the oath. And one of the fundamentals is that she will not, in any other situation or circumstance, share views expressed at their meetings, or otherwise. Now she is out there in public trying to sort of dissociate herself from the consensus that the Council of State reached when they were considering the petition. Now, whether she agreed with the majority or not, because a consensus binding on each and every member of the Council of State. So it lies in a mass to come out, and take a contrary position. I mean, that is not good governance. And it doesn't show maturity to say that, because as a former Chief Justice, she remains a justice in retirement. And one of the judicial oaths that she also subscribed to was to uphold and defend the Constitution of Ghana. And if the president, has acted in accordance with the provisions of the Constitution, and she doesn't like, the outcome, it is not for her, to go public and sort of, run amok, on the protest. A respectable Chief Justice will not do that, So that is, where I am coming from. That's why this one I said she has nodded a little. Former Chief Justice of Akpaloo is a very eminent, distinguished, and respectable, former Chief Justice. One of Ghana's Treve, and therefore she should be the last person to do what she did this morning. I would have thought that she would have declined any invitation, to go on air and attempt, to say that she was in complete disagreement, with the majority of members of the Council of State. That's why, I said that
right.
She should be
but Mr.
reprimanded by the Council.
I agree that you said she had sworn the oath of secrecy, but looking at the public nature of this particular issue and the kind of interest it has generated, if she held an opinion that was contrary to what the entirety of the Council of State had held, it wasn't. It shouldn't be out of place for her to share it. Do you agree?
There are conventions, that bind governance. It's not only the Constitution. We have conventions. And, one such convention is that, if you belong to an association or a society or a board, and the board has taken a decision, in this case, the Council of State, mind you, the petitions were forwarded to the Council of State. He remains a member of the Council. And, we are told that in consultation with the President, the Council of State, expressed a certain view, on the sense of which the President and the Council said that the prima facie case had been made out. So when the President decided to set up the five-member committee, it was pursuant to the advice, by virtue of the consultation the President held with the Council of State. She is a Council, State member. Whether, she agreed with them or not, whether she attended the meeting or not, the consensus is binding on her. So she cannot, come out, and air her view, that, she doesn't agree, in the first place that there was even the need, for that. Whether she agrees or not, is neither here nor there. And some justice, her views are very, very critical, to the comment that the Court of Public Opinion attracting authority. And so, in order that our governance, leaders and those in leadership would differentiate between drawing a line, of least resistance, where they can go, where they can trade, and all that. Because, governance issues are very critical to the sustenance of our democracy.
Right.
So if, we are going to allow, every member, of a governing institution or agency to express individual views on, what the collective, has decided, it is going to,
problematic.
lead to, a point of absurdity,
right.
if not, chaos and anarchy.
Absolutely.
You can then, every morning, look at what this person is going to say, what that person has had to say. So
Okay.
for me, what he did, is inappropriate, to say the least.
Okay.
It was in bad taste, as she herself, tried to say that, the committee's approach was in bad taste. So her approach, is equally, in bad taste.
Right.
This is my view.
Certainly, very well appreciated. And the final bit of the conversation has to do with the fact that right on the back of the decision to finally dismiss Madam Gertude Torkonoo, she has gone back to the ECOWAS court asking that judgment be delivered in her favor because Ghana failed to respond in time to the concerns that were raised by the ECOWAS court following her filing of the case there. The Deputy Attorney General says that in as much as we are members of the ECOWAS, the final decision of ECOWAS is not entirely binding on us, or to some extent, it will have to go through a certain process before, if they have to be activated in Ghana, that be done. How does this come to you? The fact that first she has activated or asked the court to rule in her favor, and the Deputy Attorney General's response?
Okay. Former Chief Justice Torkonoo's famous says the law is the law. So the Honorable Deputy Attorney General has indicated the position of government. And you see, I believe that in one of your shows, I did point out, that the ECOWAS action will not have, any binding effect, as a decision of the Supreme Court or the High Court or any of the Superior Court of Judicature of Ghana will have. And, the ECOWAS mechanism is one, that is binding, in honor only. So it doesn't have that binding effect as such, unless the president goes back to Article 75 of our Constitution, and ignites all the processes, that will be required in order to, make the ECOWAS decision, one that can bind Ghana and for the Ghana government or the Republic of Ghana, to be able, to do what is to be required. So as far as I'm concerned, the government stands, has the support of law. So that's it. But the second one, other one is a timeline. So if the applicant was given time to file, her processes, and she complied with that, and the respondent, that is the Republic of Ghana, was equally given a timeline and has not complied with it, then the failure to comply with the timeline will not to the benefit of the applicant, in this case, former Chief Justice Gertude Torkonoo, and therefore she has every right to file an application for judgment in default. However, judgment in default, is not a judgment on the merits of the case. So it is always able to be set aside at the instance of the respondent. The government can decide that may decide is to find a response with the legal, the ECOWAS Commission, and the judgment may not be granted. But even if it is granted and that's why, an application for extension of time within which to file a response,
Right.
it will not be pronounced. So it could, unfortunately,
unfortunately, Council, the line isn't too clear at the moment, but we are grateful for for making time to speak with us. Thank you so much for this evening, Mr. Ansasari. Right, we've been speaking to Kweku Ansasari, who is the former director at the Ghana School of Law, sharing his thoughts on how all of the issues surrounding Madam Gertude Torkonoo has played out in the last 48 hours, with the latest being the fact that she has asked the ECOWAS court to rule in her favor, following the fact that Ghana failed to file within time when the ECOWAS court had asked it to bring specific information regarding why she was being investigated as Chief Justice. This is still 3FM 92.7. Now, Anna Nijinde, a private legal practitioner, has also been sharing his perspective on the default judgment that the Chief Justice is seeking at the ECOWAS court. He spoke earlier on Midday News.
Well, what I'm saying is that from the very beginning, receiving the petition, submitting it to President in consultation with Council of State, setting up a committee, those processes are in order. But when it came to the sitting of the committee, the processes that they adopted, some of them are very questionable. Some of them are very questionable because they started the processes even without notifying the Chief Justice as to the charges being brought against her. Even the people petitioning against her, she did not know them until she made this public announcement, and then she was served with those documents. I mean, if I'm to appear before a court, I have to be served. I have to be put on notice. Look, Mr. A, Mr. Y, or Mr. Z is suing you for this particular reason. Well, the Council of State, their role is advisory. They're supposed to counsel the President on some of these matters. And the Council of State, they work as a body. So if at that level she did not agree, she would have made her point there. But that does not take away her right to express an opinion on an important legal issue such as this.
And that is Anna Nijinde, who is a private legal practitioner. Let's go on to the big story that happened in the country. I mean, you'd recall that a lot of attention was on Akwatia